Welcome to the Texas RPLS Q&A review video. Question number 7. In addition to boundaries and easements and things like that, different kinds of affirmative defenses and also adverse possession are likely topics on your RPLS exam. When teaching the legal aspects course over the years, the students have to pick a final paper, and they write the final paper on a topic about legal aspects that they find most interesting. I don't know what attracts these young university students like moths to a flame to adverse possession, but I think they love the idea of getting something for nothing. They love the idea of taking over something and getting it for free. Sounds great to me too. But meeting the statutory requirements for adverse possession is not easy. One of those requirements is the following. In the context of adverse possession, the accrual of the cause of action refers to which of the following? What does the accrual of the cause of action really mean? A record owner's cause of action to recover from the adverse possessor, the adverse possessor's claim, the record owner's claim, adverse possessor's right to occupy the property, or none of the above.
Loving this video? Hit the subscribe button below. Be sure to click the bell next to it to get the latest prep videos before anybody else.
Texas has two types of law: judicial law, made by the courts, and statutory law, made by the Texas legislature, the House and the Senate. Adverse possession is statutory law, and that means that this is a legislative act. But there are court cases which explain these statutory acts and help us figure out what's going on. So let's read one of those cases, and let's see if the case explains what this accrual of the cause of action really means. According to a case of BP versus Marshall, where the statute reads, "to the cause of action accrues," this language refers to the record owner's cause of action to recover adversely possessed land, not to the adverse possessor's claim or any other claim of record. Read that 5 more times. Well, it kind of solves our question, but let's really think about how this works so we know the correct answer and why it's correct. Adverse possessor shows up on day 1. Adverse possessor knows that in Texas, to recover under the code, he must occupy this property for 7 years. Okay? So beginning on day 1 and ending on day 2,554, that is 1 day before the 7-year clock hits. Any time between those 2 days, day 1 and day 2,554, the true owner can show up and kick this guy off at gunpoint. And if you're a Texan, I hope you have lots and lots of guns. Then you're going to have to figure out, well, can I boot this guy off or not? And as long as the 7-year period has not hit, you can boot the adverse possessor off your property. But on day 2,555, that is 7 years to the day the adverse possessor appeared, now the adverse possessor has a claim of right. He can take your property from you in the Texas courts. So, what is going to happen here? I, the true owner, am going to boot you off before year 7, or I, the record owner, have just lost my property, contingent on the other factors at year 7. So my cause of action is to kick your butt off of my property. And I can do this up until that statutory period. And that's exactly what this case is talking about. Therefore, the correct answer is A. Record owner's cause of action to recover from the adverse possessor. Would you like even more? We have created an entirely comprehensive Texas RPLS exam course. It's got slides, videos, practice questions, and handouts. And we go over all the major topics on the RPLS exam, and we give you the information you need to pass on the first try. Included is a full-length 8-hour practice exam, which will get you ready for this exam and get your mind set on game day. Go to nlcprep.com/RPLS for more information.